Good morning,
Morning.
Mr. Medina
Yes, ma'am.
Delgado. Good morning.
Good morning.
So we're here today for your preliminary hearing. So we're going to get started with that. We can begin right now.
Okay.
Good morning. I am Parole Officer Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Medina-Delgado Ismael, number 380081. Today is December 27th, 2024. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. This is a public hearing, and public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Yes, my name is Ismael, ISMAEL, Medina, MEDINA, hyphenation Delgado, DELGADO, inmate number 380081.
Thank you. This is a preliminary hearing, which for three purposes under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing and placing you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits that are filed for the record. You will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of the hearing, I will inform you of my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure right now?
No, ma'am.
Okay. You important rights today, the right to have an attorney present. Do you want to continue without counsel?
Yes, ma'am.
You have a right to receive the written notice of charges of violations. You received that written notice?
Yes, ma'am.
You have a right to view the evidence against you, right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so now review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So charge 1 under release direction GPS, your charging officer reported on 11/27/24, you're placed on GPS monitoring and you were instructed to follow a home confinement schedule. You failed to comply with the GPS monitoring agreement and did not follow your home confinement instructions from your parole officer. This violates special parole condition 1, release directions. On 12/8/24, you allowed your GPS monitoring device to shut down between 12/8/24, 9:57 a.m. and 12/10/24 to 2:30 p.m. You failed to comply with your GPS monitoring agreement, did not follow GPS monitoring agreement number 4. I am responsible to ensure the GPS tracking device remains charged by connecting the charging cable to the tracking device and plugging the charging cable into an electrical outlet for at least 2 hours each day. This violates special parole condition number 1, release direction. Charge 2 under release direction curfew, your charging officer reported at 11/27/24, you're placed on GPS monitoring and you were instructed to follow a home confinement schedule. You failed to comply with the GPS monitoring agreement, did not follow your home confinement instructions from your parole officer. You failed to comply with conditions on 12/7/24 and 12/8/24. This violates your condition number 1, release direction. On 12/7/24, you were observed during review of your GPS on the Allied Universal Electronic Monitoring System, not complying with the GPS agreement. You left home at 1:36 a.m. did not return home until 1:53 a.m. On 12/7/24, you're observed during review of your GPS on Allied Universal Monitoring System, not complying with GPS agreement. You left home at 2:15 a.m. did not return home until 2:56 a.m. On 12/7/24, you observed during a review of your GPS on the Allied Universal Monitoring System, not complying with GPS agreement. You left home at 4 p.m. did not return home until 5:35 p.m. On 12/7, you're observed during review of your GPS Allied Universal Monitoring System not complying with GPS agreement. You left home at 5:50 p.m. did not return home until 6:54 p.m. On 12/7/24, you observed during review of your Allied Universal Monitoring System not complying with your GPS agreement. You left home at 7:03 p.m. did not return home until 11:39 p.m. 12/7/24, you're observed during review of your Allied Universal Monitoring System not complying with GPS agreements. Left home at 11:46 p.m. did not return home until 1:59 a.m. on 12/8/24. On 12/8/24, you observed during review of your GPS Allied Universal Monitoring System not complying with GPS agreement. You left home at 2:04 a.m. and did not return home until 3:04 a.m. Upon review of GPS, these violations were not throwing points as shown in Exhibit G. Charge 3 in no bail laws drug as your charging officer reported on 12/10/24. You admitted to covering officer that you had used heroin on 12/10/24. You signed a voluntary admission form, violates special parole condition 2, obey all laws. On 11/27/24, you admitted to your PO that you misused your Suboxone and used cocaine and fentanyl on 11/24/24. You signed a voluntary admission form. This violates special parole condition number 2, obey all laws. On 11/19/24, you admitted to your PO that you recently used fentanyl. You signed a voluntary admission form, violates your special parole condition, obey all laws. On 9/10/24, you admitted to your PO that you used fentanyl and overdosed on 9/5/24. You signed a voluntary admission form. This violates special parole condition number 2, obey all laws. On 9/4/24, you admitted to your PO that you used fentanyl. On 9/3/24, you signed a voluntary admission form. This violates special parole condition, obey all laws. The state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, Connecticut Conditions of Parole. B, Connecticut Board of Parole Remand to Actual Custody Order. C, Notice of parole violation, notice of parole rights. D, parole violation report. E, voluntary admissions. F, GPS monitoring agreement. G, allied GPS monitoring history GPS maps. H, app foundation letter. I, issued misconducts. J, decision information summary. And K is revocation hearing summary. Did you receive the notice of parole violation report, and those other documents I marked, and did you review those?
Yes, ma'am.
Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. So what I'm going to do, I'm just going to swear you in under oath so you can speak today if you'd like to. Can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, ma'am.
All right. Would you like to say anything right now in regards to the charges?
As far as the GPS, I did speak with Mr. Pio Hernandez when he came in last Thursday because my sponsor was moving, so she had to change the power to the other apartment, like I had told him. So I couldn't charge it because I had to stay in that apartment, but he was on vacation. So when I was called in to go into parole, which I knew they was going to lock me up because of the GPS, I ended up using and told them that I used again. For the past 2 years, as a few parole officers already know, it's been a struggle for me because I lost my mom on Thanksgiving of 2022. So I've been like basically like on a self-destruct war path with myself, so yeah, it's been really hard for me, and I'm not proud of it. I'm embarrassed. I'm humiliated. And I mean, like I really need some help. You know what I mean? And that's what I've been trying to tell them over and over again. And I just keep getting switched from parole officer to parole officer, and it's been a struggle. And when I signed the agreement for the GPS, it was only till I went to the App Foundation, and then they said because they said that I said that I wasn't taking my medication, that I didn't qualify to go. And he ended up going on vacation. So before he went, I said, can I go to a detox? And he told me no. And then when he came to see me here last week, he told me, oh, did you ever go to a detox? I said, you told me not to go because I was on the bracelet. He said, oh, no, that was a miscommunication. I'm like, well, I mean, like, well, here I am sitting in jail right now, over all this miscommunication stuff. But when I signed the paper for the GPS, I was only supposed to be on house arrest only till I went to the App Foundation. It wasn't supposed to be anything over that. It was just for a week. And he's new. So I guess, I don't understand, but if I'm guilty of it, I'm guilty of it. That's all I got to say.
Well, I appreciate your statements regarding that. Unfortunately, I mean, they could say it's a week, and then if things aren't going right, it could be extended, as much as time is needed. So unless they say you're done, you're not done. So
yeah, I didn't know that. I apologize for that too. I just want to stop killing myself and, just want to get back on track and just do what I'm supposed to do the way I was at the beginning in 2018 all the way until all this until 2022 when I lost my mom. You know, I just want to get my shit back together. Sorry for the excuse for the language.
I understand. And I do appreciate your comments, and I hope that you're sincere in wanting to change. Cause I mean, you've been in top before. I mean,
yeah, this like I said, for the past 2 years, just been like a self-destruct. Like I've just, you know, it's.
I hear you. I understand what you're saying. But I'm sure that these home confinements were for your benefit and not anybody else's. I'm sure this was an attempt to, you know, help you go back into compliance. And unfortunately, it doesn't appear that happened, which is why you're here. So what I'm going to do next, I'm going to announce my findings. So,
Okay.
Regarding that charge one, I do make a finding of probable cause on GPS. This is based on the evidence that I have supported by state A, F, and G. On charge two, I make a finding of probable cause curfew based on the evidence presented in support of the violation, which is exhibits A, F, and G. And I make a finding of probable cause on obey all laws drugs. This is based on the evidence and testimony presented in support of the violation, which is exhibits A, E, and I. I do find the acts are serious enough to warrant revocation. Every time you should be detained while you wait for revocation hearing. So you have a technical violation. So that means we have 60 business days from the day you were remanded to hold your revocation hearing. So I will schedule you for that and bring you back, and then we determine if there's a violation or not, and what if any sanction would be imposed at that time. So I will see you soon, probably in February. Okay.
All right.
All right. So I'll see you soon. I wish you the best of luck, sir. I hope you can do programming in there or something while you're waiting. You're all set for today, though.
All right.
Good luck, sir.
Thank you.
You got Young coming up in a minute.
Thank you.
Were you doing? Since you're back to 85, it's 155.
Good morning, Mr. Young.
Good morning.
Good morning. We're here today for your revocation hearing.
Yep.
So we're going to get started. Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing starting Young Mark number 281718. Today is December 27th, 2024. This hearing is being conducted via video at the BOPP Central Office in Hartford Correctional Center. This is a public hearing, and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Mark Adam Young, 281718.
You have counsel here today. Please identify yourself.
Hannah Dean on behalf of Mr. Young. Good morning, sir.
Good morning, Hannah. How are you?
Ed, how are you doing?
Good.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background history. Do you have any questions about the purpose or procedure?
No.
You have important rights today. The right to have an attorney present. You have counsel here. You've received the written notice of charges of violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, I am.
All right, so we'll now review the charge. State your appeal is bringing against you and information underlying each charge. Charge 1, restriction of misconduct. You're charging officer report of 1924. You signed out of the Stein halfway house at 8 a.m. to attend a job fair at FHI in Manchester. With a return time of 12 p.m., you contacted the halfway house at 2 p.m., stating you were waiting to be interviewed and provided a new return time of 4 p.m. You failed to return to the halfway house at that time and contacted the halfway house staff at 6:15 p.m., saying that you were running late. You did not make any further contact with the Stein halfway house staff and never returned to Stein halfway house. Your only parole-approved residence located on Charter Street, Hartford. Numerous attempts to locate you were made via phone calls to your cell phone, family members, local hospitals, and police departments with negative findings. Parole staff made multiple efforts to physically locate you in the city of Hartford and the town of Stratford Springs with negative findings. You made no effort to contact your assigned parole officer or return to the Stein halfway house. Your whereabouts in the community have been unknown since 1924. Under charge 2, obey laws, obedience to the law. In charging off support on 3/6/24, you arrested by Hartford police. Current charges are possessing controlled substance first offense, criminal trespass 3rd degree, interfering with the officer resisting. On 3/7/24, you were arraigned at Hartford GA 14 under docket ending in 62498-S. Your next court date is 3/26/24. Based on your behaviors, your violation of prohibition will obey all laws. On 3/6/24, you were arrested by Hartford Police Department. You had it in your possession and control at the time of the arrest. This is under drugs. 3 wax sleeves, stamped Lamborghini, 2 of which contained a white powder-like substance. A portion of the substance was revealed, drug tested, which revealed a positive for fentanyl. Based on your behaviors, your violation of prohibition bail laws will not use or have in possession control any illegal drug, narcotic, or drug paraphernalia. Charge 400 additional conditions, halfway house placement. I labeled this parts 1, 2, 3. Part 1 states on 12/5/23, you're found possessed of a marijuana pipe as well as a vape, as is a violation of halfway house agreement, stating I will not possess vape pens inside the halfway house, and I will not consume or possess marijuana in the halfway house. Part 2 states on 12/7/23, your employer reported that you were released from your job at 8:45 a.m. and would have been due to return by 10:45 a.m. You failed to return to the halfway house until 4:30 p.m. This is in violation of halfway house agreement, stating that I will only go to locations indicated on approved community pass unless changes have been authorized by parole. Part 3 states on 12/15/23, you signed out of the Stein halfway house for work at 6:49 a.m. However, you failed to report to your place of employment as scheduled. You did not return to the Stein halfway house until 5:30 p.m. This is in violation of the halfway house agreement, stating I will only go to locations indicated on approved community pass unless changes have been authorized by parole. And the state has filed the following exhibits pre-marked for identification purposes. As Exhibit A, notice of parole violation. B, notice of parole rights. C, remainder extra custody order. D, PC assigned conditions. E, halfway house agreement. F, Community Solutions Incident Disciplinary Report. G, offender misconduct. H, Community Solutions Incident Disciplinary Report. I, Community Solutions Inc. Incident Report. J, offender misconduct. K, Community Solutions Inc. Disciplinary Report. L, offender misconduct. M, Community Solutions Inc. Incident Report. N, parole violation report. O, the Hartford Police Report ending in 5909. And Exhibit P is CT Judicial Branch pending case detail, and 4 docket ending in 2498-S. Did you receive notice of parole violation report, and those other documents I marked? Did you review those?
Yes.
And counsel has filed the following exhibit pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
We do not.
We don't have any witnesses. I'm going to put on the record, I received an addendum from PCS. The addendum reported to 6/24, BOPP did issue an absconder warrant for the offender on 12/9/24. The offender was convicted of possession of controlled substance first offense, received an unconditional discharge with all their charges nollied. So it is now defense's opportunity if you'd like to speak at this time.
Yes, thank you very much. As to the absconder charge 1, I don't have any comments. As to charge 2, that is accurate. There was just one plea to one count of possession of a controlled substance. It was just an unconditional discharge, no probation, no time to serve, and all other charges were nollied. As to charge 3, drugs, I would just note that there aren't any of the tests and evidence. No confirmatory testing, I believe, was completed, just those field tests, but we unfortunately don't have those as part of the evidence. So I would argue for that one that the standard has not been met. And as for charge 4, no comments.
Thank you. Right, so what I'm going to do next is I'm going to announce my findings. So on that charge 1, I do find you violated condition police direction absconder based on a warrant being issued by the BOPP and evidence that was provided in support of the charge, exhibits D and N. On charge 2, I find you violated condition, obey all laws, obedience to law. This is based on your conviction of possession of controlled substance first offense and received an unconditional discharge with all the charges nollied. On charge 3, I do find you violated condition, obey all laws, drugs based on evidence provided, which was exhibits D, O, and N. And on charge 4, I do find you violated condition halfway house placement. That's parts 1 through 3 based on evidence provided in support of the charge, which is exhibits D, E, F, G, part 1, H, I, J, part 2, and K and L on part 3. So that includes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome we will recommend. So if you would like to at this time.
Yes, thank you very much. Mr. Young is 42 years old, born in Rockville, Connecticut, raised in Stafford Springs. His primary support in the community is his adoptive father and his 2 sisters. They also reside in the Stafford Springs area. He also has one 20-year-old son who lives in Manchester. Most recently, while released on special parole, he was placed at Community Solutions Steinhouse in Hartford. Previously, on discretionary parole, he successfully completed the Drakelet Center in Bloomfield. He then transferred to special parole supervision in January of 2019. At that point, he was sponsored by his mother in Windsor Locks. He did successfully complete detox at Rushford in Middletown back in November of 2020, and thereafter completed inpatient programming there as well. He has experience working in the restaurant industry, doing construction and the stagehanding industry. Most recently, he had a part-time job at Dr. Energy Saver Warehouse in Windsor, Connecticut for a couple of months. He was part-time at UPS in Windsor, Connecticut as well for 1 month. He does snow removal on the side and also had a job secured at ATUSA Manchester and reports that he was starting to begin work there as a selector. Previously, while on parole, he had a full-time construction job at Dr. Energy Saver for 1 year back until he broke his rib, unfortunately, and had to have a leave of absence. Beginning in the summer of 2020, he was doing the stagehanding for the concerts. Unfortunately, that did come to an end because of the COVID-19 pandemic, and thereafter he had some unemployment until more recently getting that position at Dr. Energy Saver and the UPS in Windsor, Connecticut. Most recent treatment he completed, he did do some outpatient treatment with Community Renewal Team, CRT, in Hartford. He was doing that once a week for 2 months. They were doing transitional case management with him. He was working with a recovery coach there, Manny from CCAR, once a week over the phone and in person. And then he also did previously do outpatient at CRT Hartford as well. Mr. Young unfortunately did suffer a TBI back in 2016 as a result of a seizure. His skull was fractured and he suffered a severe bleeding in his brain and was in a coma for approximately 9 hours. He is hoping to establish primary care services in the community to help with that. He reports volunteering previously at the Rockville, Connecticut Soup Kitchen. Also, he attends church on Asylum Avenue in Hartford. While incarcerated, he's been doing the methadone programming, getting medication-assisted treatment. He voluntarily enrolled in Tier 1, which he attended for 5 sessions until the facilitator went on a leave of absence. He reports that he was referred to the next session. Upon reinstatement of his special parole, he would like to be placed at a Hartford area halfway house or alternatively a halfway house in in Norwich area. He's interested in studying business. He wants to one day open his own construction company. He wants to pursue the job that he previously had secured at ADUSA, the selecting position. He's hoping that they will have something for him there in Manchester, Connecticut. He's amenable to any sort of treatment recommended, and he's interested in continuing to do relapse prevention groups and remaining on the medication-assisted treatment. He also hopes to remain active in his church. He has been incarcerated since March 6th of this year, which is approximately 9 months. I would argue that that's more than sufficient for these allegations, and I would just ask that he be released as soon as possible. Thank you very much.
All right, I'll be right with you, the recommendation. Yeah, so he has been in since March 6th.
Yes, I believe so.
No, they find, don't find it. They always do. That was- I mean, that would help. No, sure. Yeah. Right.
So, I did review all this evidence, listen to testimony. I will, upon the record, you were out there for less than 3 months before you absconded, from parole supervision. You did receive the new conviction with unconditional discharge. You have a prior, violation for absconding, in which you received a 6-month sanction for that violation. As you received as well 3 misconducts while you were only being watched for 3 months.
So, I mean, where's Walker coming from?
So based on all this information, and the fact that you have been in since March 6th, I am going to recommend that parole be revoked and that you be re-paroled for January 9th, 2025. This ends up being about a 10-month security confinement, I believe. That seems right.
Yeah.
I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, a general no contact with Ashford Spirit Shop, 215 Pompey Hollow Road, Ashford, Connecticut. My findings are going to the parole board on January 9th. Just want to make sure that is, yes. So the board will review your case January 9th. If they agree with me, you'll be released that day. You are special parole, so you would be out that day if they agree. If they didn't agree with that, you'd still be there after that day, and you'd know the board disagrees with you. You'd get something in the mail telling you why, and then you'd come talk to the board if they want to hold you in any longer. You are on supervision until January 26th, so that'll give you a year left on supervision. I hope you take advantage of the opportunities that parole can offer you in regards to your treatment, instead of running from. Obviously, you need some help out there, so please use your parole officers as a form of help if you need it, okay?
Yeah, I will.
Okay, so I'm trying to give you another shot before you're done to get some help. So you're all set for now. Take advantage of the housing you get. I know halfway houses sometimes can be hard, but talk to your officer and people in the house to help you out, okay?
Okay, thank you. I appreciate it.
Okay, you're all set.
Good luck to you, sir.
Thank you, Ms. Dean.
What's that? Here you go out here, I'll get you out in a minute. They got something going on in the hallway, just have to see out here.
We'll put on the record inmate Burgos Joshua, number 244208. Preliminary hearing has been continued to January 6, 2025. On the record regarding Markey Michael, whose hearing is scheduled for 11 a.m. at the Corrigan Correctional Center facility. His number is 390-805. This hearing has been waived at this time. Good morning.
Morning.
I just have Bugg.
He should be coming in shortly.
Okay,
All right.
thank you.
Mhm.
Morning, Mr. Bugg.
Good morning.
Good morning, Jamar.
Can you hear us
morning.
okay? Good morning.
Yeah, I did.
So Jamar, I know we talked about I was going to file a continuance request, but I was looking to get some information and I didn't get it right away. So I'm just going to do it today on the record, okay?
All right.
Okay.
All right, so I'm P.O. Meisinger, I'm hearing examiner for the Board of Pardons and Paroles. This is revocation hearing, and we have Mr. Bugg Jamar 3200903, and today is December 27th, 2024. And this hearing was being conducted via video at the BOP Central Office, MacDougall Walker Correctional Institution. And Mr. Bugg, can you just state your full name and DOC inmate number for the record?
Jamar Allen Bugg 320903.
Okay, and you have counsel here?
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Bugg. And it is our request today for a continuance. I am still looking into some other information in regards to his case. I would like a continuance till January 15th, if that's possible.
So I'll grant the continuance to January 15th. So then at that time, we'll conduct your revocation hearing. So we'll see you again on that date. Okay, sir?
What's this hearing is for though? They already told me I gotta finish my 8 months.
You didn't have revocation hearing yet. That's what.
Huh?
I don't know who told you that, but that would be decided at your hearing, and we didn't have the hearing yet.
They sent me paperwork saying just finish your 8 months. I got
I
the
don't know
paperwork.
who's. Well, that's incorrect, because you're having revocation hearing today to decide what was going to happen regarding that violation that you had received.
It says
That's what this hearing is for.
It says the pardon the parole.
You're breaking up a
And
little
it says
bit.
finish your 8 months. It says parole. It says
All right,
finish your
I'll-
8 months, and they sent me the
Jamar,
and they
I'll schedule a legal call with you, and we can talk about that. Maybe your counselor can send me a copy of the letter so I can see it, okay?
yeah they said and it sent me the police report too. So I'm like, I'm not getting that.
Yeah, I don't understand that either. I'm not certain that that's accurate, but let's have a conversation off the record where we're not on this live hearing, and we'll talk about it, okay?
So I'll see you again on January 15th.
All right.
Okay, all right, I'll set up a call with you, okay?
Thank you.
Yeah.
Good morning.
Hey, hi, good morning. How are you?
Good, how are you?
Good. Happy holidays.
Happy holidays to you too.
Mr. Gray is who you needed this morning?
Yes, please.
And Mr. Reynolds has been canceled. Is that correct?
Yes, he's been waived, so he does not need to be present.
Okay. You didn't need anybody else today, right?
No.
Hey,
That's it.
Sid. What up, kid? All right,
Thank you.
yes, ma'am, yeah.
Good morning, Mr. Gray.
Good morning.
Morning, we're here today for your revocation hearing. Okay. So we're gonna get started with that. Phil McNeill, you can hear me okay?
Yes, ma'am.
Okay, perfect. All right. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Parties and Paroles. This is a revocation hearing starting Gray Richad, number 268861. Today is December 27th, 2024. This hearing is being conducted via video at the BOPP Central Office in New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state to me your full name and DOC inmate number for the record, sir?
Richard Gray, 268861.
And you, new parole officer present, can you please identify yourself for the record?
Officer Crystal McNeill, out of the Waterbury Special Management Unit.
Thank you. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better we do evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is basically place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present our relevant testimony. After the state is finished, you will have the same opportunity. After considering all of the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. Important rights today, the right to have an attorney present. Do you want to continue without counsel?
Yes.
You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights? Are you ready to move forward?
Yes, I do.
All right, so now review the charge the state your PO is bringing against you and the information underlying each charge. So PO McNeill, if you please read the charges.
Okay, charge 1, reporting, excuse me, on 10/2/24 during a home visit. You were instructed by this officer that your next report date would be on 10/8/24 at the Waterbury Parole Office in the morning. A text message with this information was also sent to your phone by you responding the next day, 10/3/24, asking if you would be going to jail. Confirm that you received this text the officer sent informing you of the next report date. On 10/8/24 at 8:28, you text this officer stating that you are running a little late, having issues with the brakes on your truck. This was an avoidance to report to the office. This officer texts you at 12:07 p.m. reminding you that the expectation is that you report to the office. This officer made several attempts to contact you but was unsuccessful. You made no further attempt to contact this officer and failed to report to the office by the close of business, 4:30 p.m. On 10/9, this officer instructed you via text to report to the office that day since you never showed up the day before. You never responded to this officer's text or calls. You failed to contact this officer and failed to report to the office. Do you need me to read the finding and all that?
Just read the charge 2.
Okay, charge 2, drugs. On or about 7/7/24, you use cocaine. On or about 8/1/24, you use cocaine. On or about 9/2/24, you use cocaine. On or about 9/20/9/24, you use cocaine. On or about 10/19/24, you use cocaine.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, arraignment of actual custody, B, special parole condition, C, notice of parole violation, D, notice of parole rights, E, parole violation report, F, 5, misconducts, G, voluntary drug admissions, 5, H, pre-biotic lab result, and I is text message of reporting instructions. Did you receive the notice of parole violation report, and those other documents I marked? Did you receive, review them, sir?
Yes.
Do you need to continue this hearing to obtain any additional evidence? Mr. Gray,
I'm sorry, can you repeat that?
do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses. So at this time, I'm going to swear in Mr. Gray as well as P.O. McNeill so that you can both speak today should you choose to. So can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury.
I do.
So,
I do.
okay, so P.O. McNeill, at this time, the state is going to have the opportunity, if you'd like to speak to any of the evidence submitted at this time or regarding the violation. Would you like to say anything at this time?
Yes.
Go ahead.
So just, I wanted to mention on the no finding on the reporting charge for 10-9, on the last page of the evidence exhibit I, it does show, and I drew an arrow towards it, that he was instructed to report. The text was on Wednesday, 10-9 at 7:55 a.m., instructing the offender to report to the office. And then also, I just wanted to point out the offender. I wasn't able to attend the last hearing, but I was able to go back and watch it. He stated that he reported to the office the next day. That's incorrect. And I have case note interaction supporting that. The offender, let's see. He was avoiding my texts and calls. I didn't get in contact with him until October 11th, which is when he called me. And then he finally came to the office on October 15th. So that's almost a week after he was supposed to report. And I also have case note interactions to support that.
Right. Is there anything else in regards to charges?
That's it.
Okay. So now is your opportunity to respond to parole violation charges against you. Remember that you may remain silent if so choose. So Mr. Gray, would you like to say anything in regards to charges at this time?
Yes. Did you tell me what day 10/15 was?
It was a Friday.
Was it
I'm
Friday?
sorry. 10/11 was a Friday and 10/15 was a Tuesday.
Right. I'm a little confused because I thought I showed up that week, the next day, because I lost my brakes completely. And that was on the way home from parole. I didn't think it was the following week.
It was the following week because remember our conversation where when we did meet, you didn't know what day it was, and you said that you had been on a binge up at the casino. You remember that?
I do remember talking to you about the casino, yes. Yes. But I guess, I ended up fixing my truck. It wasn't an avoidance to not see you. My brakes were out. They were bad, very bad. And I did go to the automotive store because I asked my mother for some money and she loaned me some money to buy the parts to fix the truck. So I'm a little confused on the dates. I never argued with you. I always owned up to everything I did. The cocaine. Yes, I have a problem with cocaine, and I thought we had a deal that we were going to do an inpatient. I was waiting for the bed, and that was what was on the table, and then it was just swept off the table, and you remanded me. Or the DOC.
Well, I
remand.
want you to speak to me. I don't want you to speak.
Oh, I'm sorry, I'm sorry.
I'm the one that's asking you if you want to say anything in regards to the charges. So I don't want to hear, he said bickering back, and I just want to know, what do you have to say in regards to these charges?
I thought I showed up. I really did, but I don't have any written. The only thing I would ask to see is the book that I sign in every week at DOC.
Is that a question?
I have no evidence.
No, you don't have to. I know what you said at the prelim, so that's already noted what you said. So
Okay.
I understand what you're saying.
All right, I'm stating that it wasn't an avoidance to see parole, because I told her I was dirty already. There was no avoidance at all. It was just an issue of driving the truck without any brakes. And on East Main Street, the brakes let go completely, and I dumped brake fluid all over the road and lost them completely. That's all I have to say.
Okay. So I'll be right with you with my findings. All right, so on charge 1, I do make a finding on police direction reporting based on the evidence provided, which is exhibits B and I. I don't make a finding on the 10-9 date. There's no evidence that the offender received this text message, or there's no responding to the text message to show that he understood he was supposed to be there. So no findings still on the 10-9 date. On charge 2, I find you did violate Obey Law's drugs based on the evidence that was provided, exhibits B, F, and G. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. McNeill, would you like to say anything in regards at this time regarding his going back into the community or background history or anything?
I just want to say, I think Mr. Gray needs a hard reset. I've worked with him to the bone. We tried pretty much most of what we could. The interventions just weren't working. I think he just needs to take a good time out and reset. Based on his history, he knows what he needs to do. It has to come from within himself. So hopefully, he could take this time out to get right, so he could come back out and be successful this time.
Thank you. So, Mr. Gray, at this time, you'll have the opportunity, if you'd like to say anything in regards to your future plans going back into the community or what you plan on working on. You can speak now.
Yes, the problem is within me. I agree 100%. I'm either living in the future and then the fear and anxiety pops up, or I go back in the past and the shame and the guilt pops up, and so I medicate myself. I don't want to feel any of those things. And I just started working with a psychiatrist, which I never, ever talked to a psychiatrist about my mental health or anything. And I just started before I was remanded. I probably wasn't telling him everything I had to tell him because I was in active addiction then, right? I've been in here for, 60 something days, almost 90 days, whatever. I've been working on myself. I did a 40-day program out of a book. Yes, I agree. I have to dig deep. It's the problem again, is me. The drugs is just a solution. I just don't want to feel that pain, that guilt anymore, and I'm willing to go work back with that psychiatrist again. I'm willing to go to a halfway house. I'm willing to do whatever I have to do. I had a good job out there. I had a place to stay. I had a vehicle. I was paying taxes. I was doing everything right except my addiction. And I'm getting too old. I'm running out of time here. I'm running out of time. My mother's, she has cancer. She's getting older. I lost my father when I was in here before, and I don't want to do that with my mom. So I'm willing to do whatever it takes.
Well, what is it gonna take? What do you think that you need to work on when you get back out there? What is your immediate plan that you need to?
I need to work on my guilt and my shame that I hold so deep down inside me. I need to talk to a person one-on-one and let that out. I already did it with God, and now I need to talk to another person.
Okay, so you like to continue either seeing a psychologist or a therapist? What about your addiction? How do you plan to address your addiction in the community?
Well, I put together 5 years. That was the longest I've ever did. Then I did 8 years in jail. I don't count that, but I know drugs are here, and if I want to use them, I could. But I put together 5 years out there in the world, and I have to surround myself with people that are doing the same thing. I have to engage back into AA. I have to go to groups. I have to do the 90-90. I have to do the groundwork.
What halfway house area do you want to go to?
I was in Waterbury. I was in the Chase House.
No, not where were you? Where do you plan on going? What area do you want to go to?
Waterbury.
You want to stay in Waterbury?
Yes.
Are you connected to treatment in Waterbury?
Yes, I am.
So where were you going? Where do you plan on?
Wellmore.
So you want to continue going there?
Yes, if that's possible.
Okay, that's possible. Okay, is there anything else either side would like to say, before I consider a recommendation?
No.
Okay, so I'll be right with you with my recommendations. I will put on the record, you were out there for about 4 months and 21 days before you were returned to custody. You are serving 8 years special parole. You have a prior violation for absconding back in 2020 and a prior top placement that you were just in as recently as 2024. You have received 5 misconducts while you were out there for almost that 5-month period. Based on the information I have, I am going to recommend that parole be revoked and that you be re-paroled for April 28th of 2025. This is about a 6-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with your victim DP, behavior management program for domestic violence, and mental health evaluation and treatment as deemed necessary. My findings will go to the parole board January 9th. So the board's going to make the final decision. They can agree with me for the 4/28/25. They can lessen the sanction as soon as 1/9, or they can they have the ability to revoke all special parole if they do. They do have the ability to do that. You'll get everything in writing about a week after January 9th. That's what the board's decision is. And you'll see what the stipulations are for your re-parole date if they re-parole you back out there. Do you have any questions?
So you're recommending me to stay in here till April 28th, is that correct?
That's correct. That's my recommendation. So the board will review everything and then they're going to make the final decision. And like I said, you'll know a week after January 9th, you'll get it in the mail from the board and it'll tell you what their decision is. Okay, so I hope you do programmings in there, connect, see the mental health in there, see it. Everybody you can, use the resources before you come back out so you prepare yourself. And hopefully, I wish you the best of luck when you come back out.
Thank you.
Okay, you're all set, sir. Thank you, P.O. McNeill.
Thank you.
Have a good day.
You too.
So on Peel Meisinger, hearing examiner from Board of Pardons and Parole, regarding, this preliminary hearing for Reynolds Victor 119109, today's December 27th, 2024. Hearing being conducted at the BOPP Central Office in the Haven Correctional Center. This is a public hearing, public access to hearings available via video live stream. We have, if you'd like to.
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit. I did have an opportunity to speak to Mr. Reynolds this morning. Unfortunately, I did have a call set up with him earlier in the week, but the call never came in. After speaking to my client and explaining to him what the purpose of the preliminary hearing is, he is elected to waive his hearing. Currently has a case pending in Waterbury Court for January 14th, 2025. As soon as he resolves that case, I will be asking that the Board of Pardons and Parole schedule him for his revocation hearing.
He was made aware of all his.
Yes, yes.
Okay, so I'll accept the waiver on record, and we will have a revocation hearing upon disposition of his criminal charges. Good morning.
Good morning.
Morning, Mr. Galarza.
Yes.
Morning. We're just, we're gonna connect to,
Just give the script.
yeah, go ahead.
Jonathan, how you doing? It's Attorney Sirica.
That's it.
All right, so Jonathan, we're gonna have a interpreter available to you. When I spoke to you, you told me you understand a lot of things, correct?
Yes.
All right, so what we're gonna do, instead of him having interpret every word, if there's something that she's saying you don't understand, raise your hand. That way, and then I'll have the interpreter interpret for you, okay?
Okay.
All right.
So we're gonna get started in a little bit, okay?
We can't start till 10:45 because it's streamlined, okay?
Okay.
So 2 minutes.
Jonathan, we're trying to get the interpreter on the line for you, okay?
Okay.
I turned off mute so you can talk.
Interpreter, if you can press *6 to unmute. Can you hear us?
Yes, one moment. Let me connect the Spanish legal interpreter with you.
Thank you.
Thank you for holding, interpreter. You are now connected to the call. Please go ahead.
Yes, hello. This is your Spanish interpreter, Hector, ID 1A096. Is your client present?
Yes.
May I proceed to greet your client and explain that I will be interpreting, that everything said will be kept confidential, and to guarantee the quality of the call, I will need to speak in complete by short sentences?
Yes.
Thank you. Buenas, yo soy su intérprete y le voy a traducir todo lo que se diga. Toda información dicha en esta conversación será mantenida en forma confidencial y para garantizar la calidad de la llamada, por favor, me habla despacio con frases cortas. Thank you, ma'am. You might proceed with the call.
Thank you, man. Go ahead.
Hector, Mr. Interpreter, this is Attorney Sirica. My client, Mr. Galarza, does understand some English. So I think what we're going to do is he's on video. If there's something he does not understand, he's going to raise his hand and you can interpret that. So we don't need word for word interpreting.
Yes, sir.
Thank you.
Thank you. All right, so,
You're welcome.
Mr. Galarza, we're going to get started. Like he said, if you do not understand something, please raise your right hand so we can have the interpreter interpret for you, okay?
Okay.
Okay. So good morning. I am P.O. Meisinger, a hearing examiner for the Board of Paroles and Paroles. This is a revocation hearing concerning Galarza Jonathan, number 435-869. Today is December 27, 2024. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state for us your full name and DOC inmate number for the record?
Nombre Jonathan Galarza, número 435869.
And you have counsel here today? Identify yourself.
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Galarza this morning.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, that is, the better or weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge that the state, your parole officer, is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present our relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure right now?
No.
You have important rights today. You have the right to have an attorney. You have an attorney here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
He did. I did speak to him. He did get the paperwork.
Okay. You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I understand.
Okay. Okay. So you now review the charge the state appeal is bringing against you and the information underlying each charge. So charge 1 under bail laws, obedience to the law. Your charging officer reported on 6/24/24, you were in possession of 8 knotted plastic baggies containing a rock-like substance, a sandwich bag containing small pieces of a rock-like substance, and 2 glass pipes with burned residue. Subsequently, you were arrested by New London PD for use of drug paraphernalia and possession of controlled substance first offense. On 5/25/24, you were involved in a motor vehicle accident and drove away from the scene. Subsequently, Montville PD issued you a summons to court for following too close and evading responsibility. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A is parole agreement, Exhibit B, parole violation notice, C, parole violation report, D, remand back to custody, E, New London PD police report ending in 6998, F, Montville Police Department crash report ending in 7818. Did you receive the notice of parole violation report, and those other documents I marked? Did you review those?
You got the paperwork I asked you about on the phone, correct?
Yeah.
Okay. And counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence? We have no witnesses. I will put on the record, I received an addendum from PCS. The addendum reported on 10/15/24, the offender was convicted of possession of controlled substance, first offense, received a 30-day jail sentence. That sentence was completed on 11/13/24. He was also convicted of evading responsibility, injury, property damage, and received a sentence of 11 months, execution suspended with 2 years probation, with all other charges nollied. So it's now defense opportunity. If you'd like to speak to any of the evidence at this time.
Just briefly regarding the first part, that is correct. He did receive a 30-day sentence on a misdemeanor charge. He served that 30 days, and the other motor vehicle charge, he did receive a suspended sentence with a period of probation to follow.
So what I'm going to do next is I'm going to announce my findings. So on that charge 1, I do find you violated the conditional bail laws, obedience to the law based on your conviction of possession of controlled substance first offense and received a sentence of 30 days jail, as well as evading responsibility, injury, property damage, and received a sentence of 11 months, execution suspended 2 years probation. As I previously stated, the EOS was 11/13/24 for the 30-day jail sentence. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to at this time.
Yes, on behalf of Mr. Galarza, my client is 29 years old. He does have one child who's 1.5 years old. Prior to his remand, he was at the Connection Reentry, the REACH program in Willimantic. As far as his education, he did receive an associate's degree in computer programming from a university in Puerto Rico, and then he did complete 1 year of barber school in Puerto Rico. As far as employment, my client did work full-time at Falvey's Motors in Norwich, worked Monday through Friday from 7:30 to 4:30 and some overtime on Saturdays. He was there for approximately 5 months. Also worked full-time at Popeye's Kitchen in Norwich for about a month and a half. Did report to us, participated in outpatient services, group and individual therapy at CHR in Willimantic. He is interested in learning in ESL program to improve his English language. He's indicated to us he's able to return to his full-time position at Popeye's Kitchen in Norwich, and also had a job lined up at Foxwoods Casino. Mr. Galarza, I know you had indicated for a sponsor, Motris Davis, correct?
Mm-hmm. Yes.
Do you have, I know you're supposed to get back to do you have an address and a phone number?
I tried to contact him, but I don't got his phone number, and I tried to see if one of my family can contact him, but I don't.
Do you have the phone number?
No,
No, how about an address?
not an address neither.
All right, do you know what town he's in?
It Hatfield.
Hatfield?
Taftville?
Yeah.
So if you were going to a halfway house, because I would have to put that as a recommendation right now because you don't have sponsor info. So if you get it, you can submit it. But right now I'd have to put a halfway house. What halfway house area would you want to go to?
Hartford or Norwich. No.
Okay. Which one? So I know you got possibly a job at the casino. Do you want to put Norwich first and then
Yes.
Hartford? Okay.
Yes.
Want to make sure. Okay, perfect.
Anything else?
Yeah, as I was saying, so yeah, he's been incarcerated since September 17th of 2024. My understanding, this is his first violation. So I said he believe he has a sponsor. We just got to get to the address and the phone number. But the Norwich halfway house in that region of the state works. It does have a job lined up, so that's all I want to add about his background.
Thank you. So I have listened to testimony. I reviewed all the evidence by the state. I will put on the record, you were in the community. You went out on transfer parole for about 6 months before you were returned to custody on new charges. I do not see any prior parole violations or misconducts that were issued during this time period. However, you are on supervision, discretionary parole supervision for sale of narcotics. And once again, you seem to have an issue with having drugs on you, as well as you received the new convictions for evading responsibility, as well as possession of that controlled substance. So based on all of the information I have, I'm going to make a recommendation that parole be revoked and that you be re-paroled for February 18th of 2025. This is about a 5-month period of confinement as a sanction. You are on parole until November 7th of 2025 right now. So you have time to go back out into the community for supervision. I recommend the following parole conditions: halfway house placement, operation of a motor vehicle, and no contact with your co-defendant, Zenith Aguila, without PO's permission. My findings are going to the parole board on January 9th. So the board is going to review your case, and then they're going to make a final decision on when your re-parole date is, if they like to re-parole you. So they can re-parole you as soon as that date of January 9th, as well as they can agree with my date of February 18th, or they can revoke all discretionary parole if they would like to. Your discretionary parole, so that is an on or after date, just like when you were granted parole. So if they give you February 18th, that's an on or after date, if the board gives you that date, okay? You will get it in writing from the parole board what their decision is about a week after January 9th in the mail. Yeah, and could the interpreter just interpret that for him, please?
But Hector, Mr. Interpreter, could you interpret this for me, please?
Yes, sir.
Okay, so after hearing the evidence, the sanction by the hearing examiner is 5 months.
Después de escuchar la evidencia, lo que le están recomendando es de que le den un castigo de 5 meses.
Your new re-parole date is February 18th of 2025.
La nueva fecha para usted estar enfrente del parol sería febrero 18 del año 2025.
It's going to the Board of Pardons and Parole on January 9th of 2025.
Va a ir al comité de parol y de perdón, va a ir la fecha de enero 9 del año 2025.
The board can adopt the recommendation.
El comité puede adaptar la recomendación.
They can give you less time or they can give you more time if they choose to.
¿Le pueden dar menos tiempo o le pueden dar más tiempo si ellos deciden hacerlo?
If they don't agree with the recommendation of February 18th of 2025, you would be entitled to a separate hearing.
Si ellos no están de acuerdo en cuanto a la recomendación de febrero 18 del año 2025, usted tiene derecho a tener otra audiencia.
Do you understand that?
Okay, sí,
¿Entiende eso?
sí,
Okay,
okay.
and one last thing, as the hearing examiner told you, you're on discretionary parole, so that if they adopt the recommendation, it's February 18th, 2025. It's on or after date. They don't have to release you right on February 18th.
Si usted está en una libertad, va a estar en libertad bajo palabra discrecionario, o sea que si ellos deciden si van a adoptar la decisión en febrero 18 o no.
Okay, entiendo.
You understand that?
Do you have any questions?
Yeah, any questions,
No,
Jonathan? All right, good
No.
luck to you.
Okay, so you're all set today.
okay, thank you.
Thank you. Thank you.
Thank you, Hector.
Thank you for calling. This is Spanish Interpreter Hector, ID 18096. You have a nice weekend. Thank you.
Thank you, you too.
That was an easy.
A communication error